The Courts of Justice Criminal Law Subcommittee of the House will come to order. Clerk, please open the roll. Members indicate your presence. We have a quorum. Thank you. The patrons we have in the room by... Okay. Senator Mulkey.
Thank you, Madam Chair. Members of the committee, we're going to do SB 689.
HB 689.
Yes.
Senate bill.
Yes, ma'am.
I said H. Excuse me.
That's okay. I almost called you Senator Watts, so we're good. So this bill is, it just does one simple thing. It protects Department of Social Services workers and local social service, well, I had that repeated, sorry, from oral threats the same way we already protect teachers and healthcare workers. Right now, under Virginia law, if someone walks up to a teacher on school grounds and threatens to kill them, that's a Class 1 misdemeanor. If someone threatens a nurse at a hospital while they're doing their job, same thing, Class 1 misdemeanor. But if someone threatens a DSS caseworker or a local social services worker, perhaps because the caseworker acted, in a situation like to remove a child from a home or denied an application for benefits, there's no specific protection under the code. Sure, like general assault and harassment statutes exist, but this category of worker has no targeted protection, and they are at risk given the work they do, the decisions they make, and the actions they take. This bill closes the gap and adds DSS employees and local social services workers to the existing protected category. The same penalty as teachers and healthcare workers receive, which would be a Class 1 misdemeanor for an oral threat made while they're doing their job. The work that DSS workers do can be very contentious. Some people are experiencing their worst days on the days the DSS worker shows up and has to deliver the news that the child may be taken from the home or that type of situation. And so they find themselves often in very, very unstable situations when they're doing these types of things. And so they asked if I would bring this bill and help protect them the way that teachers and nurses are protected. And so that's what this bill would do.
Thank you. Members of the committee, I'm going to reverse our typical order and ask first for comments, any testimony for anyone here speaking for SB 689? Anyone in opposition to? Okay. Then we had an identical bill on the House side.
Okay.
Which was tabled 7-2.
Oh, that's a
and
shame.
I wanted to bring out the issues so that you understood, because what you bring, as you've briefly testified, we're all well aware of.
Yes.
But currently, the two occupations are site-specific. It is on school property, classroom, buses. It is in the hospital facility, so that the disruptive behavior can affect the public, can affect the conduct of business, as opposed to what a social worker will be doing, which is out on a one-on-one. That's not to say that there isn't a problem.
Okay.
However, in looking at your bill, I'm going to confess on my continuing legal education that I discovered that assault and battery can already, for anybody, be prosecuted as a Class 1 misdemeanor. So there's obviously issues that we need to look at as to how we apply this. I'm taking the prerogative of the chair of carrying on. I had a bill, just so you know we're in good company, that did not pass. And it, hopefully with a letter, will go to the Crime Commission, and it asks for looking at assault and battery as to the amount of serious injury done to the victim, as opposed to a single penalty, no matter how severely the individual is hurt. So my suggestion, Mr. Uber Chair, is that in this letter to the Crime Commission, that we also include the issue that is brought before us as to we have a quote-unquote enhanced penalty of a Class 1 misdemeanor for teachers and hospital and healthcare workers, but in fact, it's the same as, and the whole issue of the assault and battery statute may need to have a more comprehensive look than just my concern about the degree of injury.
Thank you, Madam Chair. We'll make sure that we send a letter to the Crime Commission to have it take a look at that broad issue. So thank you.
Then it would be appropriate for a motion either to carry over or table, but with I'm sorry, if we carry over, then it's a letter. Is that correct?
Yeah, why don't I move to carry over the bill under Rule 22 to 2027, and we'll send a letter to the Crime Commission to report back.
Any discussion? Hearing none, clerk, and that's a voice vote. All those in favor say aye. Aye. Opposed? Okay. Again, your bill, SB 689, is carried over with a letter to the Crime Commission.
Thank you. That sounds fair to me. Appreciate it.
Oh, absolutely. Please, my apologies. I didn't see it.
I'm sorry, thank you. I know we had our voice vote. I did want to at least speak on this, and I think I understand the concerns with the statute generally speaking, so it's broader than just with respect to DSS. I did want to say that there are a couple of things that I did like generally about this. One was that we were talking about DSS workers, and I guess in one way, some were arguing that it's not similar to the other types of industries that are part of this. I will say that just from my personal perspective as someone who is the daughter of a retired DSS worker who was a caseworker, I particularly understand that there are instances in which there is an ongoing relationship that you have to take into account that could make it a heightened, in a lot of ways, a heightened urgency to have some kind of parameters around this specific type of relationship. I thought, and you can perhaps correct me if I'm wrong, and I think I see some DSS staff here as well in the audience, but I also thought that one of the differences between the current statute and as it relates generally to folks and what is trying to be done here with respect to including DSS workers is that first encounter would be considered a Class 1 misdemeanor, and then it would be raised to a felony if there was a second encounter, or perhaps, Senator, that was a different bill that I am recalling. Can you clear that up for me, if you don't mind?
Madam Chair, Delegate Mehta, I think that was a different bill that you're thinking of that I met with you this morning on.
Thank you for the clarification. I appreciate that.
Thank you. If there are no other comments on the bill, thank you, Senator.
Thank you very much.
The next bill then is, excuse me while I check, and that's just for the record then, at your request, Senate Bill 673 will be by for the day. Next Friday, as in 2 days from now, will be our last meeting.
Okay, so we'll be taking that one up then.
And there is, I understand, a substitute that has been put online. Is there any problem with putting it online?
Madam Chair, members of the subcommittee, in speaking with the senator, she wanted to make sure that some of the language that counsel and yourself had suggested is okay with some of the appetite in the Senate before we start making
Thank you.
official
for
proposals.
The public, a substitute is being worked upon.
Yes, so I had a lot of help from senators on the other side of the aisle in the other chamber, and I feel like I must have their input because they slaved away at that bill. So I want to run it by them before we publish it, if that's okay.
Yeah, thank you, Senator.
Thank you.
So the next patron that I see is Senator Craig, here for Senate Bill 111.
Yes, thank you, Madam Chair, members of the committee. Senate Bill 111, trespassing on emergency vehicles prohibit. So This provides that any person who enters or remains upon or within an emergency vehicle defined in this bill without the permission or after having been forbidden to do so by the owner, lessee, or authorized operator is guilty of a Class 4 misdemeanor. And I'll give you a little background on this. There were some kids that walked into a fire station in my locality and got into the ambulance because they leave them unlocked because, you know, they need to get in there quick. They were on top of the ambulance. They were videoing and doing videos. And so when they came out, they called the police and tried to charge them with trespass, but because the emergency vehicles are not in the code, they just had to let them go. And so they had to take that emergency vehicle out of service and inventory everything because there's drug kits in there and there's things like that. So they took the emergency vehicle out of service for several hours to go over and do an inventory. And so this bill allows that emergency vehicles are added into the code for trespassing.
Thank you. I have a question of counsel with this background then. The code section that you're amending was put in the code just a couple of years ago because of aggressive activities or disruptive activities on public transit. And it was put there as much to protect the public as it was the driver as to deal with the activity. What you've just described, what concerns me, and this is my question now of counsel, how could this possibly be enforced? Because if we put in emergency vehicles and the kids did the same thing on a police car, or they did the same thing on, is it an ambulance, is it an emergency vehicle, et cetera, I can see quite a Christmas tree if we put one defined vehicle in and not whatever the class should possibly be. Counsel, how else can we enforce this, or could it have been enforced? The activity that took place.
With regard to at the fire station, I'm surprised that they felt like they couldn't prosecute under 18.2-119, which is just the general trespassing statute, because that says if any person without authority goes upon or remains upon lands, buildings, or premises of another, or any portion or area thereof after having been forbidden to do so, either orally or in writing, that would be a Class 1 misdemeanor trespass. So I'm just wondering why it couldn't have been prosecuted under that code section.
Counsel, is there a word, because you've got premises and you've got building and you've got land, is there something that needs to be in there for the, to cover the vehicle or to cover any aspect of that?
I mean, it says or any portion or area thereof. I would read that to encompass that. I don't know why they felt like they couldn't prosecute them under that, because certainly if the emergency vehicle was within the fire station, they would be in a building and on a premise. So it seems like they should have been able to prosecute them under that. Based on how I'm reading the trespassing statute, which makes it a Class 1 versus this would make it Class 4. So it seems like it should cover it, but I'm not familiar with the specific.
Senator?
So, Madam Chair, I would answer that. This bill, I guess the fire chief brought this bill to our council and explained it in council. I wasn't there. And they adopted it into their package, and so it was unanimous that they felt like when law enforcement got there, apparently they were not comfortable in writing a trespass charge. And so it really affected, everybody, because it was when you take an ambulance out of service, that means, you've probably got one 20 minutes away. And so it's pretty dangerous to the community. And so they put it in their package, and that's where we're at. I do have someone for the city of Chesapeake here.
Delegate Schmidt.
Thank you, Madam Chair. I just have a question, maybe for council or maybe for the patron. Obviously, firehouses and that sort of thing are not considered like public property, but for the patron, was this parked in public? Like, in other words, would we have a problem if, there is a fire truck or an ambulance in a public space and kids decide to, TikTok by getting on top of the fire truck and filming, in other words, I know the reason we put the statute in for public transportation is like you have a right to be there because of public transportation, and then so you don't have to go through you have now been told to leave and then you don't leave and then it becomes trespass. So I didn't know if we would have a problem with, again, it's a serious matter, but, youth or even adults deciding to climb on top of emergency vehicles and TikTok. So.
I share the concern, yeah. Are there other comments?
Madam Chair? So I think the reason why they did not charge him because it was a vehicle, not real property. It was inside the fire station. So that was the issue. It was a vehicle, not real property.
So your county attorney used the phrase real property. So would that be something that we can put in the general trespass law? Again, because I'm thinking in terms of personal property when I think of it. Real property to me, as the tax person, is the land and the building, or the personal property thereof. There is a phrase that refers to what you own.
I think that's why in the bill it said emergency vehicle. That was the whole issue. Mm-hmm.
And I do think that this is something that might be useful whenever, whereas I'm very nervous about this one carve out of one type of public vehicle.
Madam Chair, if I may. So back in 2023, the way the statute came about was this was with Delegate McQuinn and Chair Bell, and there was an issue with, I think it was the City of Richmond Transit, and a person was told multiple times to get off the bus. They were forbidden to be there, but there was no enforcement mechanism to do it. So then they ended up assaulting the bus driver on the bus. So that's how we ended up with subsection F of 18.2-57, which is the assault. But the problem that we also kind of figured out was, okay, well, if I'm get a suspended sentence, but I'm convicted, that only lasts for probationary purposes 12 months. So for part of a court order, you can only be told, don't get on that bus for 12 months. So then they said, well, we're going to make the statute that says any person that's on public transportation after being told they cannot would get the class 4 misdemeanor, which would be less than the class 1 misdemeanor of regular trespass. So when you're asking about extra language to add, I do hear what you're saying about the Christmas tree effect, but it does sound like we have a generalized statute under 18.2-119, but then this one is specifically for transportation service. So adding emergency vehicle would be a subset of that kind of trespass with a lesser penalty. That's how it would be set up in the code right now. So I don't know if there's any extra language that we could add there without broadening it back up to the way that the current statute is.
Counsel, if I'm following what you are laying out, I'm thinking more in terms of amending the trespass statute rather than amending this statute. I'm thinking in terms of leaving this statute as it is for the purpose that it was drawn and broadening the trespass statute so there's no question that you could enforce it on any what I'm going to call personal property. And we do refer to business personal property, for example, in the tax code.
And I think that that would be a policy call if they wanted to add it to the trespass statute to make it a class 1 misdemeanor versus this is proposing that it be a class 4 misdemeanor, which just carries a fine, as opposed to a class 1 misdemeanor, which can carry up to 12 months in jail. That would be a policy call. So
I would also like to note, Madam Chair, if you don't mind, I typically don't like to say this very often, but sometimes when there's an ugly statute, it's been that way for a reason. This statute hasn't been touched since 2011. There's a lot of case law on what these words mean under trespass. If we start adding some extra words to it, are we opening up the door to the court interpreting the words differently? That's just that's a case law concern. I know we don't like saying that all the time, but it's a messy statute.
So with all this input, forget about orderly meeting. I understand you have some people here who have come from your jurisdiction. If they can share any information about why you felt this couldn't be prosecuted.
Madam Chair, members of the committee, David Westcott on behalf of the City of Chesapeake. This is obviously a very important bill to the City of Chesapeake, and not only the city, but also our Chesapeake Fire Department. As the Senator stated, there's really not anything else that I can add to the conversation other than that our folks at the Fire Department, these individuals asked, hey, can we take a video inside of the ambulance, not just on top, but also inside the ambulance? Our folks said, no, you can't. We'd love to show you inside of it. Our folks went back in. They looked back out there. The folks were inside the ambulance on the gurney, inside doing a music video. And at that point, I mean, Chesapeake, I mean, we're second largest city in the Commonwealth, but at the same time, we still have only a certain number of units, certain number of ambulances in certain areas of the city. And when that one ambulance gets pulled off, it puts a stress not only on the city, but also to the community and responding to calls. And it's so important to really understand that once somebody that's in that ambulance that's not supposed to be there, we don't know what's been tampered with. We have no idea what things are missing out of the ambulance. And it really creates it's a huge public safety issue. And our fire chief, as well as our police chief, as well as our city attorney and our deputy city attorney felt that the current way that things are written, that it did not cover us to be able to do anything. And this is the reason why we brought this legislation forward. And certainly we do appreciate the senator carrying the bill for us. And I believe our fire chief is online, but he's been having some issue with getting on.
If I may, one follow-up question.
Yes, ma'am.
So Class 1 misdemeanor versus Class 4 misdemeanor.
Well, we do not want jail time. We want the lesser of the penalty, and and that's shared from our city manager all the way down to our fire department. So that's the way where the city stands.
But it'd also be the will, the pleasure of the committee.
But it also is the will and the pleasure of the committee also.
So as I'm trying, thank you for the additional information. So you're very definitely carving out emergency vehicles with fire, ambulance, police cars.
Yes.
But you're not carving out anything having to do with public works or schools or anything else?
Not to my understanding.
Now, if the same situation happened, your focus is on this is an emergency vehicle that has to be available for emergencies. That is the reason that you're penalizing.
Madam Chair, from our city council to our city manager, as well as our fire chief, that is what we are trying to do here, is to really get after responding emergency vehicles. That's it.
Thank you.
And I would add, only because of the equipment and everything that's involved in a emergency vehicle.
That was helpful. Thank you. Delegate Hernandez.
Madam Chair, I just wanted to make a comment that as we're thinking about Class 1 versus Class 4, I think we should not go beyond what is Class 4 as the patron has proposed. I'm more comfortable with that than putting in as a Class 1.
Thank you. Delegate Schmidt.
I guess just as a follow-up question, maybe for the witness that just spoke, but still to go back to just clarify one more time, to go back to the original, like why wasn't this prosecuted as regular trespass if they were especially told not to go in the ambulance? That is, I thought, 18.21-119. The idea is that if you're in a public space or you're in a place where the public is milling about and somebody says you need to leave or don't go in there and you do, that's trespass. So I guess I'm trying to get to, like, why are we doing this for this one instance that there was maybe some miscalculation with prosecution?
Madam Chair, I do know our fire chief was supposed to be online.
If you could come forward, please.
Good afternoon. I'm Justin Griffith, Commonwealth Attorney for Pulaski County. So Delegate Smith, if I host you at my office and I'm giving you a tour of my office, you have a lawful right to be there. I invited you there. If I say my baseball card room, well, my son's four-wheeler's over there. Don't mess with it, please. And then I go to the restroom and I come back. You're lawfully in my office. You were invited into my office, but you're standing on top of my kid's four-wheeler. That's kind of this situation. They had a lawful right to be where they were, but they went into some personal property they weren't allowed to be in. I've never had that scenario come up before until I heard this scenario. But that's what with the law enforcement for a curve. It's like, so Delegate Smith could be here, but he wasn't supposed to be on your four-wheeler. So the police would be like, so you want me to charge him with trespass on a four-wheeler? It just wouldn't work. This does clear up lawful right to be there, told not to go in the ambulance. It just makes it easier regarding the vehicles. I don't know if that helped at all. But
Delegate Hope.
I just, maybe this is for council, and maybe I'm just too slow, but I just want to make sure that the definitions of what we're describing here, emergency vehicle and public transportation service, is that narrow piece. Is that something that's in an amendment that we adopted, or?
It's defined in the bill.
But doesn't public transportation says passenger transportation provided by bus, rail, or other surface conveyance? I mean, I thought I just heard that we're just talking about emergency.
So pursuant to 46.2-818.2, which is the definition section where we said what emergency vehicle is.
Okay.
There's a list 1 through 7. So just to summarize, law enforcement vehicle, regional detention center vehicle, fire vehicle, EMS, Department of Emergency Management vehicle, DOC vehicle, or any vehicle authorized with equipped alternating, blinking, flashing lights, which is your highway safety stuff.
Okay. All right. Thank you, Madam Chair.
And one more question that I have as follow-up. I see public throughout this, so it does not apply to privately owned ambulances or any of that type of vehicle. Anything that's privately owned.
It would apply to a public transportation service or an emergency vehicle. It is not distinguished between public or private. So if you can see it looks like an ambulance and you're climbing on an ambulance, you're climbing on an ambulance. So you would be subject to this trespassing if you had been told not to do so. No matter if it was a publicly owned City of Richmond EMS or a private company that then transports people to and from hospitals. Correct?
Right. The public transportation it's showing as an amendment because that was moved up because there was a definition section created. That was already part of the statute and already defined. This is just an amendment to include emergency vehicle to be trespassed as a class 4 misdemeanor, and then emergency vehicle is defined by the code section that Mr. Hatcher read, and that's defined by statute.
Thank you. Are there any other comments? Is there anyone here wishing to speak for the bill that would add to what has already been? You're definitely registered as being for this, right? Is there anyone here wishing to speak in opposition to Senate Bill 111? Okay, and there's no one online. So we certainly have discussed this thoroughly.
Yes.
Yes.
He's trying to log in.
And the fire chief, I understand, tried, but has not been able to connect. For the record. Okay. We operate by motion.
Move to report.
It's been moved and seconded that we report Senate Bill 111. Any further discussion? Seeing none, clerk, please open the roll. Members, cast your vote. I close the roll, and with all of the discussion, Senate Bill 111 passes by a vote of 8-0 unanimously.
Thank you, Madam Chair, members of the committee.
For your input. The next member who is here is Senator Reeves. Senator Reeves.
Good afternoon, Madam Chair and members of the committee. I have before you Senate Bill 559. Madam Chair, this bill is before you at the request of my Commonwealth Attorney, Russ Rabb, who's here today. And rather than me try to explain it to you and have him re-explain it to you, probably a little easier to understand. If you're okay with it, Madam Chair, I'm going to yield the mic to my Commonwealth Attorney to tell you what he's trying to solve. Would that be okay?
Absolutely. Thank you.
Thank you, Madam Chair. Russ?
Madam Chair, members of the committee, my name is Russ Rabb. I'm the Commonwealth's attorney for Culpeper County. And what we're attempting to do here is amend Section 19 .2-245.1, which is the forgery venue statute. What we have seen is a proliferation of check washing cases. These are cases where somebody in Culpeper sends a check through the mail. It's then intercepted either in the mailbox, it's intercepted at a distribution center like in Merrifield, or at any point along the way. The check is then washed, and maybe a new figure is put on the check, but definitely a new name is put on the check. It's then distributed to other people who are typically in other jurisdictions to go cash at their banks. These checks are often sold for money, say $100 each to others. They cash it at their bank. What the forgery venue gives us is venue to prosecute forgery where the uttering of the forged check took place. So if the check is stolen from Culpeper but passed in Richmond, the forgery could be passed in Richmond. The forgery could be, prosecuted in Richmond. The forgery could be prosecuted in Culpeper. The uttering or passing of the forged check by the individual in Richmond could be prosecuted in the city of Richmond, but cannot be prosecuted in Culpeper County where the victim resides. And so the amendment that I've proposed is to categorize the primary or the statute with the primary forgery and uttering statutes, 18.2-168, which is forgery and uttering of a public record, 18.2-170, which is forgery and uttering of banknotes. It's typically for counterfeit currency. And then most importantly, 18.2-172, which is usually used for forged checks but can be other documents. Currently, venue is shared for forgery, but it is not shared for the uttering. A subsection of this allows prosecution to occur where the victim suffered or entity suffered a financial loss. So this could cover a business as well. And so it's to essentially put these back together to allow forgery and uttering to be prosecuted in the home community. This is similar to identity theft, which can be prosecuted where the victim resides. And it's to keep it in one place. And that's what we're attempting to do.
So my follow-up question is, I absolutely understand what you're talking about with these three types of forgery, but by the way in which you're changing the statute, you're leaving out every other type of forgery. Why wouldn't you just change the statute to apply to all forms of forgery?
So in looking at the other statutes, typically the other one is credit card. It's in the credit card theft section or credit card fraud section, and that's already addressed in that section. Otherwise, it doesn't offend, the forgery doesn't really offend any other, this venue change does not offend any other code section.
So in your experience, it's only credit card that would be not included. Can I turn to counsel? Are there other types of forgery that we are now separating out two statutes, one for these three types and one for credit card? What possibly are we missing?
That's what Mr. Hatcher and I were talking about, because the way we had read it is that essentially that the venue would be for anything under Article 1 forgery that could be prosecuted. If they're saying they're having trouble with being able to prosecute the uttering under the forgery venue statute, it might be, we had discussed maybe saying something like violation including these things that would also cover the forgery article, or saying something like a violation of Article 1 that specifically lays out it's the forgery article. How I read the current venue statute, it would cover that, but if they're saying they can't prosecute the uttering but only the forgery, it might be better to say something like including, so that it wouldn't limit it to just those three, or article prosecute.
There's no other forgery statute. I apologize if I'm
Yes, thank you. Please continue, and then please continue, counsel.
That was just our suggestion that we talked about.
That you have an amendment to make this less only covering these three, leaving a door open in case another type of forgery might fit into here.
Because like 18.2-169, which is not listed in the amendment, is forging or keeping an instrument for forging a seal. So I mean, I don't know if they want that included or not. We just felt like it may limit certain things if it was amended. So maybe
yes.
to say including.
Madam Chair,
You wish to respond?
Yes, the other code sections, such as the seal, that is done where venue would typically occur, where the seal is kept. Regular venue already covers that code section. This was vetted through the Virginia Commonwealth Attorneys Association. While they don't take a position on this bill, what they did determine is it does not offend any other statute. And so that's why I proposed it in this manner, in order to just make it very, very clear that these matters are covered by these code sections. So it's black and white.
If I now may respond, I'm still having problems. If the original statute was not limited to three specific things, why can't the original statute be amended to allow venue in wherever the venue needs to be for whatever the forgery is? Why do we have to have these three things spelled out in a statute that didn't have the three things spelled out, but that statute covered those three things?
So, Madam Chair, when the venue statute's been cobbled together over time, the last amendment occurred where essentially to include venue where somebody suffered a financial loss. That was several years ago. And then the statute also then has another subsection that covers that forgery may be prosecuted where the uttering takes place. But what I am attempting to do here is essentially make it clear that the forgery and the uttering can be prosecuted where it's relevant to any of these subsections, and it is trying to keep it as clean as possible.
I'm sorry to engage in this but we're not communicating. The statute before us does not have three things specified. Now, the changes that you're talking about were other statutes that were added to the code, but this particular statute was not limited to only three things. You're now limiting this statute that's been on the books to only these three things. And that's my concern about whether or not we're missing anything by doing that. And if we aren't and there isn't anything, no harm done. But if there is something that could have been prosecuted under this statute that no longer can be because now the statute's only limited to these three things, is my concern.
Madam Chair, I cannot find any other statutes that this would offend.
I'm sorry.
I cannot find any other statutes that this amendment would offend.
That's not the issue, sir. Let's try one more time. Look at the bright words before you. You've added three specific code sections that were already covered under this statute. So they don't need to be spelled out because they're already covered along with whatever else. So why do we need to have those in there, though limit your change to only those three? What harm is there to have it cover those three plus everything else, which is what the statute currently does?
Yes, Madam Chair. What the statute currently does not cover under 18.2, 168, 170, or 172 is the uttering of those documents where the person who suffered a financial loss resides. So what the statute currently allows is if the check is forged in Culpeper and uttered in Richmond, the uttering cannot be prosecuted in Culpeper, and the individual would be prosecuted potentially by Richmond for uttering, and then potentially the forger in Culpeper, and the victim would then have to go to both jurisdictions to testify. This seeks to rectify that.
I really hate to do this. I totally agree and understand. We're having an ongoing dialogue.
Yes.
Totally understand the necessity for the bill, that we need to have the uttering covered so you have two different venues potentially there. My only concern is why that solution is limited only to now three stipulated areas rather than whatever is defined as forgery traditionally under this statute. Your bill, your remedy, I have no problem with. It's the application of that remedy only to those three enumerated statutes.
Madam Chair, is it possible?
Please, counsel, and then I will stop.
Well, let me just say, I think maybe what the amendment that was being proposed by council might get at your concern, Madam Chair. And so maybe we can.
Well, I was just going to raise 2 points, and then, so I think what we're talking about is when we're adding certain language, it looks like we're taking out what's been longstanding law. The statute in question really hasn't been amended substantially since it was enacted in 1979, other than adding extra Romanettes or where the venues can be. That one of them, the second Romanet was added in 2000, the third Romanet was added in 2019. So the language saying any person that commits a forgery, that forgery may be prosecuted, has been the law since 1979. When you look at 18.2-72, that statute has not been touched since it was recodified into 18.2 in 1975. So I think the issue is, by striking just the words forgery, I know you're saying it would not offend any other statute, but I think what we're trying to say is that one word, because that's always been in the code, and now we're saying 3 specific code sections are only what this venue is going to apply to. Would it be better to say forgery, comma, including any offense of statute ABC, comma, can be prosecuted? Would that get at what you are also trying to solve without removing current law that's been there since the 70s?
Madam Chair.
Please.
I am open to any amendment that will allow us to include uttering under this and would accept anything. I just want to make sure that we can just keep the victim in one place.
I think council has given you the solution.
Yes. Thank you.
Council, so we operate by motion. Moved and seconded that we amend as reported by council. All those in favor, any further discussion? All those in favor say aye. Aye. Opposed. Okay. Now, is there anyone else in the audience who wishes to speak for HB 559? Anyone in opposition? Seeing no one online, we operate by motion. Okay, it's been moved and seconded that we report as amended. Seeing no further wishes to speak, open the roll. Please cast your vote. And HB, excuse me, I keep on doing it. Senate Bill 559 reports with amendments unanimously 8-0. Thank you, Senator.
Members of the committee, thank you.
And now, Senator Obenshain.
Good afternoon, Madam Chair, members of the committee. I have Senate Bill 778.
Thank you, sir. Please proceed.
Madam Chair, this is I hope, a clarifying bill that was brought to me by the sex offender prosecutor in Rockingham County. As you may remember, in 2012, we adopted the grooming statute. And the grooming statute includes a number of things that are used to groom children for sexual exploitation. And unfortunately, I guess it designates a specific type of video, of pornography, child pornography. And what the experience has been of prosecutors is that sex offenders know that law enforcement is pretty doggone good at tracking child pornography, its use, its people who obtain it and then use it. And they are using other types of pornography to groom children, to desensitize them, to gauge their interest in engaging in sexual behavior. And my prosecutor has had a number of cases in which predators have used adult pornography to start these conversations. And this bill simply clarifies that adult pornography, if you will, non-child pornography, is a material that would qualify under this grooming statute for prosecuting these predators. Simple as that.
Thank you. Are there any questions of the patron? My only question, certainly your prosecutor in this instance is welcome to come forward if you'd like to speak any further. My question is the addition of the word lascivious that applies now to the entire statute, and what have you found that requires that clarification?
Madam Chair, that was a request of the Senate Courts Committee to make it clear that just to further clarify the type of intent that is required of the offender in order to prosecute this.
So the intent was always there, so the burden of lascivious is not regarded as being an issue.
Justin Griffith here on behalf of VACA. Yes, it has to be shared with the child with lascivious intent and with the intent to do it to groom them or normalize the activity. So lascivious intent's required and the intent to groom. VACA supports this bill. I can answer any questions you guys have. I have a case in Pulaski I could talk about this would have made a difference, I believe, in a charging decision. But we would ask that you guys pass this bill, and I can answer any questions you have.
Thank you. I see no one wishing to speak, so we've now heard that VACA supports the bill. Is there anyone else in the room who wishes to speak in favor of Senate Bill 7878? Anyone here in opposition? And no one's online. Are there any comments from council? We operate by motion. Moved and seconded, we report and refer to appropriations because of the Woodrum amendment.
Understood.
Seeing no one else wishing to speak, open the roll. Members, cast your vote. Senate Bill 778 reports and is referred to appropriation unanimously, vote of 9-0.
Thank you, Madam Chair.
Mr. Uber Chair,
Yeah.
you have had conversations with Senator McDougal about Senate Bill 142.
Yes.
How are we to treat that for today's meeting?
Yes, I mean, I can present the bill and offer amendment. I had a conversation with the patron prior and told him he didn't have to stay for it. What Senator McDougal is trying to do with 142 is to incentivize local law enforcement to enforce underage tobacco or vape sales. And so right now, whenever a local law enforcement goes in, they can't collect the fines and keep them for their locality. They have to send them to the state. So there's really no incentive to do that. I'd let him know that I'm working on a bill with Senator Eben about creating enforcement statewide to have ABC perhaps go in and be the enforcement. The issue there is that we need to make sure that that program, if it is enacted, is self-funded. And so they would rely on those fines and fees to go into for ABC, for example, to help fund the program. And I was concerned that if McDougal's bill passed, it would divert funds to the locality, not to where this more broader statewide uniform enforcement would live. So what I asked him to do is give me a chance to work my bill through and see if it can be successful. So what I told him to do is I would amend his bill to put a reenactment clause to guarantee that his bill will go into conference, likely with mine and Senator Evans' bill, and we can see if we can either mirror some language that his bill could go forward or just swoop it into the broader bill that's carrying. So that would be my motion, is to amend the bill to, with his approval, Senator McDougal's approval, to get it into conference. So it's to have a reenactment clause.
Okay.
That's an amendment.
Moved and seconded that we added a reenactment clause. All those in favor say aye.
Aye.
Opposed? Okay, and we operate by motion.
And I would move to report the bill as amended.
Any discussion? All those, clerk, please open the roll to report as with amendment. We moved in, Senate Bill 142 is reported with amendment unanimously 9-0. And that completes our docket. And again, at this point, we have just one more meeting scheduled for Friday. All right. Thank you very much. We are adjourned.